The NBC4 News at 3 starts with breaking news.
Good afternoon, everyone. I'm Colleen Williams.
And I'm Kathy Varr. We're following breaking news right now. We're getting new information from the jury in the Palisades fire. We have to be careful what we report right now because we understand there are strict rules with federal court. We do know the court did receive a note from the jury. I want to show you a live picture right now from the federal courthouse in downtown L.A. And we expect for more information to come down any moment. When it does, we're going to bring it to you.
As we've been telling you, prosecutors say there is irrefutable evidence that places Jonathan Rinderknecht at the scene of the Lockman fire January 1st, 2025. It later became the deadly Palisades fire. Prosecutors also claim Rinderknecht was angry at the rich and powerful and sought revenge here. His attorneys argue that New Year's fireworks started the fire, not Rinderknecht. He did not testify in his own defense here, but if convicted, he could face up to 45 years behind bars.
Joining us now live, one of our legal experts we use on the air here, Royal Oakes. Royal, what can you tell us about this information we're getting from the jury? We understand that some note has been passed and the court has told everyone to assemble. To us, that means possible verdict, but what could be the case right now?
Well, jurors often send out questions if they want to have testimony reread, if they want a complex legal point re-explained. Sometimes they come up with bad news, namely, Your Honor, we're hopelessly deadlocked. So we don't know exactly what's on their mind, but the fact that the judge considered this important enough to sort of pause things, let's get everybody together, it could be a very significant moment in the trial, even if it is not an imminent verdict.
But, Royal, there seems to be some confusion in the communication coming out of there right now. Is this typical?
Well, it is typical in the sense that it's a very messy situation. You've got 12 jurors, not necessarily 12 in federal court, but you have many people involved. And when you hear a question, it isn't necessarily a question from the consensus of the entire jury. It could be one person who maybe isn't using very good judgment about what they're after. So we're really kind of in the dark here. If it is the case that they're having a struggle to come up with a verdict, very likely the judge will say, go back and work harder, role play, reread the evidence. You keep an open mind. Don't let your egos get involved. Maybe somebody voted a certain way in a straw vote, and then later on the majority is coming out against them. If the judge pushes too hard, ironically, that can help the defense, because if the judge sort of leans on the jury and they say, okay, you wanted a unanimous verdict, here it is, then the defense goes up to the Court of Appeals and says, they were pressured, it really wasn't fair, we deserve a brand new trial.
What do you think of the time frame right now? Would you expect a note from the jury right now saying we're deadlocked at this point?
Yeah, no, I wouldn't expect a note saying we're deadlocked, but I wouldn't be, because it just hasn't been that many days.
Right.
But I wouldn't be surprised if they have some concerns, because you remember, he is accused of two things. First, he started the Lockman fire. He was there on January 1. He can't deny that he was in the vicinity, and he was intrigued by the fire enough to come back and videotape it himself. But then it simmered from January 2 to 7. And the question is he really responsible for the Palisades fire that erupted on January 7, or is it the responsibility of the fire department? And that's going to be having a huge impact possibly on the thousands of civil suits that are pending, where people who lost their homes and had injuries, they want the city of LA to pay big bucks to the fire department and the people who allegedly didn't fill up the reservoir with water.
Royal, in terms of time, we know that the jury has not been deliberating very long on this. What does that tell you at all? I mean, this is a big case with, as you point out, ramifications down the road here.
Absolutely. I wouldn't be surprised if they take another week. I mean, you hope that they can come to a consensus without letting it drag on. But when you have issues like, well, okay, did he start the fire? Is he also responsible for the second fire? And of course, the jury, being from the Los Angeles area, they were as emotionally wrapped up in this as all the rest of us were. And of course, that made it for a very challenging job to assemble a panel of jurors who haven't already made up their mind about who's responsible, because we heard so much publicity about who didn't fill up the reservoir, or did you lay off the firemen? Or, in the case of this guy, are you responsible for doing this? We've heard all this evidence about how he, resented wealthy people. He was a fan of Luigi Mangione, and so that would give the motive for him looking down on all these fabulous Pacific Palisades homes. Well, I'm going to light them on fire. Did that really happen? We don't know. But these are all problems that the jury can take a good long time to struggle with before coming up with, again, you need a unanimous verdict in a criminal case.
Well, how closely is the city watching this, do you think, and why?
Oh, hugely. They actually literally have their lawyers, Colleen, sitting in court watching, because there are thousands of civil lawsuits against the Los Angeles City, the LA Fire Department, all the people who maintained the reservoir that was empty. And the idea is this: if this guy is convicted of starting these fires, then the city still has to face the thousands of lawsuits, but they breathe a little sigh of relief because somebody else was responsible, not them.
All right, Roy, we just got some information that's coming from inside the court, and this is what we're learning. This is a quote. We have a subsequent note. The first note was at 2:03 this afternoon. The note is from 2:30. The first note had the box checked that the jury had reached a unanimous verdict. This note says, quote, "We have people on both sides that are dead set, that are unwilling to change their opinion. We're at a standstill. We're unsure how to proceed." What do you make of that?
Well, that's kind of silly, isn't it? Because the first note says, yippee, we've reached a unanimous verdict, and the second one says we've changed our mind. I think what happens is that people do say, okay, I'm inclined to vote a certain way, but then they start going down the jury verdict form, and there are all sorts of complex sub-questions you have to answer, and sometimes jurors realize, I guess we're not in agreement after all. I mean, you think back to the Menendez brothers. They were convicted of murder in their second trial. In the first trial, there were 12 jurors. 3 wanted murder 1, 3 wanted murder 2, 3 wanted voluntary manslaughter, and 3 wanted involuntary manslaughter. They couldn't agree on a single count, and as a result, what happened was the Menendez brothers were found guilty of nothing, although they, of course, were found guilty in their second trial. So, yeah, jurors change their minds, and it's sometimes hard to slog through a very complex verdict form.
All right, well, we're going to put you on hold for just a moment. As Kathy mentioned, we have people inside the courtroom watching all of this go down. One of them inside the courtroom this afternoon has been our own Eric Leonard. Eric, what can you tell us about what transpired there?
Yeah, just a bizarre set of circumstances. I just walked out maybe a minute ago. The fact that we got a signal that the jury had reached a unanimous verdict, and then while we were sitting in the courtroom, after all of the lawyers had come in, and the defendant himself, Jonathan Rinderknecht, had been brought in from custody, he was sitting there as well. The judge went through a little bit of an introduction with all of the lawyers and said, well, let's bring the jury in. The judge said to everybody, we received a note from the jury that they had reached a unanimous verdict. And we waited, and we waited. Minutes passed. And then the court clerk came in without the jury and handed a note to the judge on a white piece of folded paper. The judge read it, pushed the microphone to the side, and sat and looked at it, went through some paperwork for a moment, and then began reading this second note to the to the courtroom, which I believe you just heard from. And she says, the first note said the box was checked, we have a unanimous verdict. The judge said, this note indicates the jury requests the following: we have people on both sides that are dead set, unwavering, and unwilling to change their opinion. We are at a standstill and unsure of how to proceed. This was clearly not what anyone was expecting to come out of this. We had not only the lawyers on both sides, the defendant there, all kinds of people from the courthouse, from the U.S. Attorney's Office. The head of the ATF in Southern California was sitting in the back row, all of them waiting to hear what they certainly thought was going to be a decision from the jury. So now this creates an interesting legal situation for both sides. On the one hand, the judge has some ability to try to help the jurors resolve whatever the disputes are between them. Although, as you heard in the wording that the jurors sent, it sounds like there's not a lot of latitude there. They're pretty locked into whatever positions they have, some guilty, some not guilty. But the judge can do a few things. Number one, the judge can offer to have particular testimony read back if that testimony is going to be something that helps the jurors reconsider or think through a particular area where this dispute lies. Another option is to have the lawyers re-argue the case, meaning The evidence that came in during the trial, the witness testimony and all of the evidence, that's kind of in lockdown. That cannot be changed. They can't bring in anything new at this point, but they can have the lawyers look at the issues where the jurors have this disagreement and essentially give an amended or an updated or an extra closing argument, which gives the prosecutors and the defense attorney an opportunity to, I don't want to call it spin, but argue their side of what that particular piece of evidence or that testimony means, and maybe that helps jurors get a clearer understanding of which way they may want to go, and then the jurors can go back and deliberate further. All of that must happen. There's a law that says before this judge can say there's no point in going on any further, they have to try all of this stuff. And then at some point, if the jury comes back and let's say they say, well, we don't believe any additional argument is going to be helpful, we don't believe looking through the exhibits or hearing testimony back is going to be helpful, the judge can give them a specific judicial order, a legal order to go back and continue deliberating. And if that doesn't work, that's when we would wind up in mistrial land, meaning the jury is deadlocked, they can't reach a verdict, and the trial ends with the likely possibility in this case that the government would try to present a second trial, retry Jonathan Rinderknecht. Again, he's facing those 3 federal arson charges. One of the possibilities that the court was considering before the trial even began is that the jurors could split on these charges, guilty on some, not guilty on others, or other. That's clearly not that is not what has happened here. But again, just this very bizarre situation where the jury sent a very clear communication that a unanimous verdict had been reached on all charges, and then as we were sitting in court, sent a note saying, sorry, we're hopelessly split here, and we don't know what to do.
Eric, while you stepped outside to talk to us, our other person in the courtroom has just sent a note that the judge wants to take a short recess, and they should be back in court in 10 minutes.
Yeah, and the recess is for 2 reasons. I was just going to say there's 2 reasons for that recess. One of them is that the prosecutors and the defense lawyer want to get together and try to agree amongst themselves about how to respond to this jury's note. The judge had offered 2 possibilities. They could bring the foreperson in and do an in-court question and answer with the foreperson, or they can send a written note back to the jury. And the lawyers, while I was in there, opted for sending a note back. So that means they have to get together outside of the judge's presence, decide what language everyone can agree on about what to tell the jurors, what their options are for getting additional readbacks or having another chance of miniature additional closing arguments. Once they agree on that, they'll present it to the judge, and then it's up to the judge to decide how to proceed. Both things could happen here. The judge could look at what the lawyers agree on and say, I don't, judge, agree with this, and I would like to speak to the foreperson. One thing they have to be really careful about is, even though we know the jury is split, we don't know how the jury is split, and there are some issues with finding that out while the jury is still technically in deliberations. So if they were to bring the foreperson in, one of the limits on that is that the judge would have to caution the foreperson, no matter what you are asked while you are sitting here, do not reveal to us how things stand in the jury room right now. That must remain secret until things get further along.
Just wondering how much trouble all of this causes when you're looking at a possible appeal down the line, the fact that they came back and there was this miscommunication, or does that happen sometimes just because jurors have different verbiage, maybe what they call something, we've reached a verdict, but what they mean is an impasse?
Yeah, that's an interesting question. I'm not quite sure, especially if we were to go on and let's say there was a mistrial, hypothetically, and there was a second jury trial put on in this case, and that verdict might be the subject of an appeal someday. Whether the jury made this miscommunication or not certainly could be something people will be talking about. I don't know if it presents a legal challenge. It's just perplexing. The verdict form is pretty clear. The lawyers worked this out in open court prior to this happening. How, if the jury was so split and so locked into different sides with no agreement on the 3 counts that they're considering, how that could be communicated to court as a unanimous verdict. But it could just be a check the wrong box kind of situation and nothing more than that.
Wondered about that. All right, Eric, it's 3:15 on a Thursday afternoon. These folks have been tied up in court for 3, almost 4 weeks at this point. What are the chances they'll be back tomorrow morning, do you think, there?
Well, it's interesting because the jury earlier today, now obviously we don't know what's going on in the jury room. We can't speak to anybody, but we do see them coming in and out of court. We have a little communication with the court clerk. It was our understanding earlier today that not only did the jury order lunch today, but also made plans to be here tomorrow. At least they informed the court they expected to be here tomorrow. So it doesn't necessarily mean anything, but it's a signal to all of us who've been on a stakeout here trying to figure out what's going on, that it did not appear, at least as of a couple of hours ago, that the jurors were close. They were planning to work until 3 o'clock this afternoon. They worked from 8 to 3 yesterday. So if midday they're already telling the court we expect to be here tomorrow, then it stands to reason that they're not close to a decision, which is all the more reason that the announcement right around 2 o'clock that a verdict had been reached was surprising, because it was pretty clear to us that they would be back tomorrow, that no decision was going to be reached today. And I'll tell you one other thing. The thing that tipped us off that there was a verdict today, the court was going to tell us and give us a few minutes warning, but not a lot. But we found out before that note went out, because a bunch of the summer interns from working for judges and also for the prosecutors all of a sudden poured out of the elevators and converged at the courtroom doors. They knew before we did, and that was our signal that something was happening.
All right, so we're on this 10-minute recess now. We're probably 5 minutes into it. We're expecting everybody to gather again. What should we be looking for? What do you think will happen next? And could this be the end of the day for today?
Yeah, it's likely going to be the end of the day, because this was already the sort of the end of the scheduled workday for the jurors. They get to set their own schedule, by the way, as long as they put in a full day's work. The judge says it's up to you when you show up and when you leave. The jurors here picked 8 a.m. to 3 p.m., so we're pretty much reaching the end of their workday, and I imagine the court will respect that. As for what will happen when everyone comes back to court, we'll get a decision from the parties, the prosecutor and the defense lawyer, about whether they have agreed on language in a note to send back to the jury. What do we do next? Is there something the court can provide, whether it's readback of testimony, an additional instruction from the judge, although really they have to stick to the language they used before, so she would just be rereading, the judge would be rereading the instructions they already have, or if there's any additional closing argument that the lawyers can provide. Those are going to be the options. It's just the language of how they're going to present that to the jury is what's going to be discussed when everyone comes back into court. If the judge is okay with it, that note could go back to the jury right away. If the judge has some issues, there could be some additional discussion. And it's also possible at this point, the judge may feel, independently of what the lawyers on each side want to do, that it's important to hear from the jury foreperson, and she could certainly have that person come into court and answer some questions about this. All of those things are on the table, and I suppose we'll find out in a few minutes.
All right, Eric, we'll let you head back into court because we're quickly approaching that 10-minute mark. But as we wait, we want to go to our legal analyst, Manny Medrano. He is a defense attorney, former federal prosecutor as well. Manny, you've been listening to what's going on here this afternoon. You have been in federal court many, many times. There's been some communication. We got a warning of a possible verdict. There seems to be chaos there. Any idea what's going on?
Here's what I think's going on. Kathy and Colleen, always great to speak with you. Thanks for letting me join you today. I've tried 60 federal jury trials downtown LA, okay, and this is pretty astounding as to what's going on right now. Here's what I think came down. Initially, that first note, the jury foreperson simply checked off the wrong box. That's what's going on. And I believe that wholeheartedly, because the second note that comes out then with the very language that we just heard, we're at a standstill, people won't change their minds, we're not sure how to proceed, that screams at the top of our lungs, hung jury, okay? And as Eric told you right now, we have no idea what the count is. Is it 6-6, 10-2 for conviction, 10-2 for acquittal? We don't know. We'll actually never find out unless there actually is a hung jury. But at the end of the day, I believe what's going to happen is that this jury, after the judge consults with the counsel for the prosecutor and the defense, after they consult, then the judge will instruct the jury. And I fully believe he's going to tell them, you know what? Get back in the jury room, get back to work. Probably not till tomorrow morning, but don't be surprised if he sends them back right now till around 4:30 to continue working. Last thing I want to share with you right now, while I wait for your additional questions, is if after continued deliberation, let's give it another day or two, and the jury note number 3 says still deadlocked, the judge can issue what's called an Allen charge, which is a charge, a jury instruction telling the jury, look, a lot of time and effort and money have gone into this trial. Please go back in and continue to work and deliberate, see if you can come up with a verdict. And after that, Colleen and Kathy, no verdict, then it's a hung jury, unequivocally.
Well, we've all served on juries. I know sometimes it does get complicated, the wording, and you want to do the right thing. But if it's as simple as checking the wrong box, how many times have you seen something so simple like happen in a case?
Well, you're asking a great question, Kathy, because with no disrespect to the jurors in this case, and by the way, I was in the courtroom 2 days ago to catch in person the closing argument by the defense counsel Haney, but I've never seen this happen. I'll be honest with you. And here's why. Both lawyers, both sides work really hard to make the verdict form as simplistic and comprehensible as humanly possible to avoid this kind of chaos. So I'm at a loss for words. It's inexplicable. I've never seen this happen in my career, either in the state cases I've prosecuted and especially the federal cases. So yeah, it's a real head scratcher, no doubt.
Manny, if in fact the jury is split at this point in time, what sort of instruction would you expect the judge to give them? What sort of note, what would it say specifically?
Yeah, it's generally described as an Allen charge, and basically the judge brings the jurors in and says, okay, look, I know you say you're deadlocked, that's what your notes say, but a lot of effort, resources, monies have gone into this trial. It's been spread out over multiple weeks. We ask you to go back into the jury room and keep working at it. See if you can have a meeting of the minds. And then they'll go back to that to continue deliberating. It's rare that I see a judge declare a hung jury in a mistrial without giving Colleen that additional Allen charge jury instruction that I just referenced. So that's generally the way this should play out if things are done correctly. But we just saw utter chaos right now in terms of checking off the wrong box. So who knows what's going to happen next when we come back from this break.
And I have to ask you, as someone who deals with this all the time, we wanted to bring our viewers, and we worked very hard to bring our viewers the correct information. So we were scrambling to say, you know, what should we tell our viewers? What do you think the attorneys in the courtroom were thinking when they got this information? And then another note.
Well, let me just, I describe it, you know, I mentor a lot of young trial lawyers, and I call it heart attack city. That's the chunk of time when you're waiting for the jury to deliberate and come back. Time stands still. You can't even eat. You're so, you know, worried about what's going to happen. So time really stands still. So I can guarantee you this, and especially Eric Leonard's a wonderful anecdote right now about the judicial externs, law students working with the federal judges right now, and they all pile out of the elevator excited because, you know, they realize that the word had come back that there's a verdict. So everything suggested we had a verdict right now, but clearly the wrong box was checked because there's no way a note would use this specific language. You know, we're in a standstill, we don't know how to proceed unless you're short of a unanimous verdict. So that's really what I expect what's going on right now. And don't be surprised the judge instructs the jurors, go back there, keep working, keep at it. Let's give it another day or two before we actually declare a hung jury in a mistrial.
If a jury is typically split, as they may or may not be in this case, how often do you ever see them all then moving forward get on the same page?
It does happen. No, you know, that's why this Allen charge was developed over a period of many decades, okay, to give jurors the opportunity to keep thinking about a case because, you know, I think Kathy mentioned she's been on a jury. I've served on 3 juries, if you can believe it or not. And when you go back there, it's a responsibility as part of our civic duty. One takes very seriously. Okay, so I think the jurors want to do right, and if they can try to be open-minded and without hostility and antipathy, and no one's screaming at each other, sometimes they're able to change people's minds. Okay, but here's one last issue. What's the number? Is it 6-6? I can tell you right now, it's going to be hard to persuade 6 people to come around to the other side. Is it 10-2, 11-1 for, you know, conviction or acquittal? That might be an easier chore to try to convince fewer jurors to come around to your way of thinking. So it really comes down to what is the split, But to reiterate, we'll actually never know what the split was until the judge says, I'm declaring a hung jury and a mistrial.
Yeah, we've been ready every day just in case, in case a verdict comes down. But how long do you think a trial like this usually takes? What were you expecting? This would have been really early if they had a verdict.
Yeah, I think either yourself or my colleague Roy a little bit earlier talked about, what does the lawyer think when a verdict comes back fast or it takes a long time? If you're, okay, I'm going to generalize a lot, okay, because I'm a criminal defense lawyer now, no longer a federal prosecutor. But if you're on the defense side, you don't want a jury to come back very quickly because that usually spells trouble for a defendant, for one's client. The longer the jury deliberates, that's generally better for the defense, okay? And in the course of my career as a federal prosecutor, I had juries come back in 30 minutes for conviction. I've had them come back in 30 days, believe it or not, 30 days of deliberations on a murder trial that I prosecuted, and they ended up convicting everyone. So it just depends, and by the way, we can discuss it later, but the evidence here is not overwhelming for the prosecution. There's a lot of reasonable doubt potentially. So maybe that'd be the cause of the current hung jury situation.
Manny, you mentioned you were in that courtroom for the defense closing arguments the other day. Walk us through some of your observations there.
Well, first of all, Mr. Haney, the defense counsel, lead defense counsel for the defendant, did, I thought, a very, very good job. He was lucid, he was cogent, made his points in a very compelling fashion. But he basically was saying the following, and I'm paraphrasing. He said, this is a circumstantial evidence case. Number one, circumstantial, of course, is there's no direct evidence, no eyewitness who saw something, for example. Okay, so it's an incredibly circumstantial evidence case. As the defense pointed out, no eyewitnesses see the defendant start the fire. In terms of forensic evidence, no accelerant was found at the spot where the fire originally started January 1, okay? So there's no direct evidence. Now, the prosecution's response to that is, you know what? You can still convict with circumstantial evidence, and it's strong. We placed the defendant at the scene of the start of the fire. He's an Uber driver. He dropped off one or two passengers. Both testified and said, the defendant was acting very erratically, very strangely, if you will. You have the defendant doing AI searches in which he asks AI, can a cigarette start a fire? And then finally, the jury heard the videotape interview of the defendant after his arrest. And while there's no admission, no confession, he acts in a very cagey, defensive way, according to the prosecution's description of that interview. So you put all that together, the prosecution's position is, we have strong circumstantial evidence. And let me tell you, that's compelling. I've prosecuted and convicted people of murder on circumstantial evidence only. So it's not to be, taken for granted in any way.
And although 12 people did die as a result of the Palisades fire, this is an arson case only?
Yes, it is. And there's a strategic reason that the prosecution did not charge murder cases. That's hard to do here, okay? I mean, it's a person starts fire, 6,800 buildings go up in flames, including businesses, 10 people die. The nexus, the cause and effect from a fire to death is a long stretch. Hence the way they indicted the case with 3 arson charges. And by the way, that the exposure under the federal sentencing laws is up to 45 years, so it's nothing to sneeze at, okay? So I think the prosecution made the right decision, avoiding murder charges per se and going with the 3 current arson charges against the defendant.
All right, Manny, as you were speaking there, we're getting information from inside the courtroom. They are back in session, that they are asking that the 3 charges be reread separately at this point. That's all the information we have. Would it be a stretch to say they could wrap this up today?
Colleen, I'll buy you a cocktail if that's what happens. I just don't see that happening. The jury is going to be read again, the actual charges. And then unless the world has gone insane, the legal world in which I live in 24/7, the judge should instruct him to go back and continue deliberating. Okay, it's too early to call a hung jury and a mistrial. That's just not done. We're too early in the game, okay, in terms of jury deliberations. So that's what I think is going to happen. Read the charges again, and probably excuse the jury for the end of the day. What are we now? Almost 3:30 p.m. And then come back 8:30, 9 o'clock tomorrow and get back to work. That's what I think is going to happen.
All right, come back fresh. Manny, as always, thank you so much. And we want to show you another live picture from outside the federal courthouse in downtown L.A. Again, jurors at a standstill in the Palisades arson trial. We do have a team inside the courtroom right now.
And for live updates anytime, head to our website, NBCLA.com. Nightly news is next.